Good morning, everyone. I hope everyone's doing well today.
Good morning, Your Honor.
Good morning, Your Honor.
Good morning.
Good morning.
Let's see. It's right at 9 o'clock. So whenever you all are ready to begin, I'm ready.
South Annex is ready, Your Honor.
Okay. And who do we have, Officer Milton?
Devil Road, position 9.
Good morning, Judge Morrow.
Morning, Mr. Finley. How are you?
I'm doing well. I hope you're doing all right too.
I am also. Let's see. Half of your screen is black, Mr. Finley.
Oh, what the heck?
I mean, I can still see you, but
That's weird.
all
Okay.
right. There you go.
Got it. Now I got it. Thank you.
I have hold for announcement for Ms. Devereaux.
Yes, Judge. That is going to be a negotiated plea, Judge.
All right. Good morning, Ms. Devereaux. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Agree to have your case heard by video?
Good morning, sir. Yes,
Good morning, Ms. Devereaux. Can you raise your right hand for me?
absolutely, I can.
Okay. Do you swear affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Ms. Devereaux. You've been
Nice.
charged in case 19 CR 004911F with loitering and prowling and 1, 2, 3 possessions of dangerous drugs. Good morning, Mr. Tortorello. How are you today?
Good morning, Your Honor. I'm fine, thank you. How are you?
I'm doing well, thank you. Is this your case?
Yes, Your Honor.
Okay, you can proceed.
Yes, this is the case of the state versus Diane Devereaux, case number 19 CR 004911F. She's charged with loitering and prowling, possession of dangerous drugs, and she has 3 counts of that charge. And the state's moving forward with all counts, Your Honor. The offer is time served 6 days and to stay away from the incident location. And the incident location is 1578 Linda Way Southwest in Atlanta, Georgia. Your Honor, on June 2nd, 2019, around 1:58 a.m., an officer Rutherford of the Atlanta Police Department was dispatched to a suspicious person call at an abandoned property at 1578 Linda Way Southwest in Atlanta. And I apologize, Your Honor. I'm not sure if opposing counsel stipulates to the facts.
I do stipulate to the facts,
Okay,
Ms. Tortorello.
thank you. So then, as far as relevant convictions, there are no relevant convictions on her record. She only has 2 cycles and nothing further from the state, Your Honor.
Can you spell the stay away address for me, Ms. Tortorello?
Yes, Your Honor. The address is Linda, traditional spelling Linda, and then Way, Southwest.
All right, thank you.
Yes, Your
Mr. Finley?
Yes, Your Honor. That is our understanding of the state's recommendation, of which we do agree to the time served. And additionally, as I just said, stipulate the factual basis, venue, and ID, Judge.
Ms. Devereaux, it's my understanding that you wish to plead guilty to loitering and prowling and 3 counts of possession of dangerous drugs. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
I'm not.
You've been represented by counsel. Are you satisfied with your counsel's representation?
I am, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, they have not, sir.
I'll accept your guilty plea as negotiated, Ms. Devereaux. Good luck to you, ma'am.
Thank you, sir. Thank you for seeing me today. You have a beautiful week.
You do the same.
Yes, sir. Position 11, Ms. Fortson.
Good morning, Ms. Fortson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Mr. Finley, I have a hold for announcement on this one also.
Yes, Your Honor. This is a non-negotiated plea. The only thing, or I guess could be negotiated, Your Honor, the only thing at issue is the restitution. The restitution.
Okay.
And
Can you rate? Go ahead, Ms. Tortorella.
I was gonna say, if restitution is at issue, we could move forward with the plea if opposing counsel is okay. And we could have a restitution hearing, schedule this for a restitution hearing afterwards. If that's something that's okay with opposing counsel and his
Yeah.
client.
Yeah, I just wasn't sure where the 882 was coming from, and Ms. Fortson was kind of confused regarding that as well. So I just wanted to inquire about that.
Do you have
Yes.
proof for the 882, Ms. Tortorella?
Yeah, so the victim has stated that it was actually $850 that was taken from his wallet. Then $32 in addition to that for the ID that he had to get because his entire wallet was stolen, including his identification. And then an additional $45 for the hat that was also taken. So it's a total of $927.
Would you like to have a restitution hearing on that at a later date, Mr. Finley?
Yes, that would be.
Okay.
Yes, please, Your Honor.
So let me get through with the plea, and then we'll get a time for the restitution hearing, which I guess we will tack on to a state all-purpose calendar, if that's all right with everyone. Ms.
Good
Fortson?
morning. Hello,
Yes, who's speaking?
good morning.
Yes,
This is Lee Crane, Vietnamese interpreter. I'm the interpreter for Cole Hu.
okay, thank you, ma'am. As soon as we get to Mr. Wu, we will get with your services. Thank you for letting the court know that you're present, though. Okay, can you hang on
Okay,
for us?
thank you, sir.
Okay, you're welcome.
Yes,
Ms.
sir.
Ms. Fortson, can you raise your right hand for the court, please? And South Annex, will you unmute? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. And in these negotiated pleas, Ms. Tortorella, generally speaking, we don't go through all the facts if Mr. Finley will admit to the venue facts and ID in the case, okay?
Yes, Your Honor.
I normally go through non-negotiated pleas and with all the facts and get in the criminal history, okay?
Yes, Your Honor.
All right, you can proceed, thank you.
Yeah, so this is the State versus Kashmir Fortson. This is case number 22 CR 001775D. She's charged with theft by taking, and the state's moving forward with said charge. The offer is 12 months, served 20 days, credit for the time served 11 days, balance probated, no contact with the victim. And the victim's name is Douglas Keith, traditional spelling for both names, to stay away from the 415 Fairburn Road, Southwest address, apartment 1416 in Atlanta, Georgia, 30331. 40 hours of community service. And the relevant convictions, as far as what I see, is there are no relevant convictions. She has 8 cycles on her record and nothing further from the state.
I've got down that you're requesting 40 hours of community service. Is that
Correct.
correct? Okay. Mr. Finley?
Yes, Your Honor. That is our understanding of the offer, Judge. We would just ask that once she does complete the community service, and if the restitution stands, once she pays that, if it stands, if she could be either not reporting or if the balance could be suspended, Judge.
Any objection to termination upon completion, Ms. Tortorella?
I'm looking to see if she has any open cases, Your Honor. Hold on. I don't have any objection, Your Honor.
All right. Ms. Fortson, it's my understanding that you wish to plead guilty to theft by taking. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the guilty plea as negotiated, Ms. Fortson. 12 months to serve, 20 days, credit for time served, 11 days, balance probated, with the stay away and the no further contact with the victim, 40 hours of community service. We'll have a restitution hearing that'll be set for a later time. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And as soon as you complete the terms of the probation, it's going to terminate, okay?
Thank you so much. Have a good day.
Okay, you have a good day also, Ms. Fortson.
Position 31, Ms. Thomas.
Excuse me, Judge. Good morning. This is Ms. Lewis. I have a question regarding about the restitution hearing. Normally, we don't schedule those. That will be, once the case is closed with us, it's closed with us. That's going to be between the PD and the state try to schedule that, because once we close the case, it goes to probation and that will be it. So normally we schedule the plea to, they have the restitution amount together. That's just FYI.
Okay, thank you. So I'm told by Ms. Lewis that you all will have to schedule a restitution hearing. And it's fine with me if you schedule it at an SAP calendar. So.
Okay, so Attorney Fanning, would you like to do it for the next week?
Yes, that's fine.
Okay,
Yeah.
if we can put it on the next SAP calendar, Your Honor.
That's fine with me. So that's going to be 7. So the 19th.
Yes.
It works.
Okay.
And so then it'll just show up on like the regular, when I get the SAP calendar, it'll be on there. Ms. Tortorella, like it'll say whatever, I guess, well.
It will be a separate calendar if that's the case, but you will be responsible to get the defendant, notification and let them know if they got to show up.
Understood. Okay, thank you.
Mr. Walker, good morning. Did you have any input?
Yeah, I'm.
Good morning, Your Honor. I'm just listening to what has been said. Typically, if there's a restitution hearing, the clerk's office has worked with us in the past to send out those notices to the defendant. So,
Well, I'm sure we can work together to get that scheduled. Okay.
it's my hope, Your Honor.
Okay, I do also. Good to see you this morning. You also, Ms. McCutcheon. Good morning to you too. Good to see you. Okay, so who do we have next?
Position 31, Ms. Thomas.
Okay. And this is going to be an arraignment and a bond hearing, is that correct?
That's correct, Judge.
Good morning, Ms. Helen, how are you?
I'm great, Judge. How are you?
Good. Good morning, Ms. Thomas. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Agree to have your case heard by video?
Morning.
Good morning. Did you hear my question?
What was the question?
We're doing this by video. Do you agree to have your case heard by video?
Yes.
Okay. Can you hear me all right, Ms. Thomas?
Yes, sir.
Okay. Can you raise your right hand for me? Do you swear affirm a testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you. Ms. Thomas, you've been charged in case 20 CR 005357B with disorderly conduct, affray, obstruction of a law enforcement officer, 2 counts. Each of these charges carries with it a maximum penalty of 12 months in jail and/or a $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen? You're on mute, but I take it that you said yes.
I do, Judge.
Ms. Thomas, how do you plead to these charges? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea, Ms. Thomas. Your case will be returned to the division judge and you'll get notification of your next hearing date. What's the current bond on this?
Your Honor, the current bond is $4,000 surety. It'll be $1,000 as to each count.
Good morning, Ms. Mitchell. How are you?
Good morning, Your Honor. I'm well.
Good. Let's see. Ms. Harrison, good morning.
Good morning, Judge.
Is there a history?
9 cycles. Last direct, I'm showing a 2000, January of this year, simple battery against police officer conviction, misdemeanor.
No, I wasn't
convicted of
wait,
Hold
Miss
on.
Miss Thomas.
Ms. Thomas, you have a right to remain silent. Anything you say can be used against you. You have an attorney here that's representing you today. I suggest that you either confer with her or let her speak on your behalf, okay?
And Miss Thomas, right now, they're just going through your history, okay? We'll address it later. Thank you.
I'm sorry, Ms. Harrison. You can continue.
Okay. 2017 possession of marijuana less than an ounce, that's in DeKalb. The first conviction was in Clayton County. A 2009 trespass, nothing further.
Ms. Helen? Well, hold on. Let me get the facts from Ms. Mitchell. Go ahead.
Yes. Your Honor, in this case, the defendant got, excuse me, the defendant got into a fight on a MARTA train car arriving at Lindbergh MARTA station. The defendant was pulling the hair of passenger Kyra, spelled K-A-I-R-A, Passmore, who's 17 years old. The defendant got upset because Ms. Passmore stood up next to her seat and leaned up against the rail of the defendant's seat. Ms. Passmore, once the defendant said something about it, Ms. Passmore stated, quote, "my bad," and moved off the rail. The defendant started cursing and insulting Ms. Passmore by saying that she needed to determine whether she was a woman or a man, and that her mother didn't teach Ms. Passmore to be a woman or a man. Meanwhile, Ms. Passmore moved further away from the defendant and leaned on another rail away from the defendant. Ms. Passmore stated and told the defendant that she's only 17 and didn't care what the defendant had to say. When the train stopped, the witness saw both women pulling each other's hair as they fell down outside the train car. The defendant refused to be placed in handcuffs, jerked her body away, and refused to walk. So she made her body go limp and sat on the ground. The defendant had to be carried by officers. So based on her history and the allegations, we're going to ask that the bond remain the same in this case, Your Honor. Nothing further.
This is a 2019 case. Is this, and she's been in for the last 3 days. Was she just arrested on these? Or did she miss a court date or?
Let me double check on that. Not that I see.
I do have an FTA in this case, Judge, but it was also due to her being incarcerated in Clayton County.
Okay, so this isn't the first time that this matter's been before the court. That's what you're telling me.
We're looking it up right now, Judge.
Yes, I see the failure to appear on November 9th of 2021. So no.
Okay. And did she, okay, and has she previously had a bond? Apparently she has. If it's was the bond set on a warrant?
I said it was set by a judge. Let me double check. Bench warrant.
Did you try to figure that out, Ms. Mitchell, Ms. Helen?
Yes, Your Honor. This is a bond hearing. Ms. Thomas is 30 years old. She is the proud mother of 6 children, a 3-year-old girl, 2-year-old, 2 8-year-olds, a 4-year-old girl, 10-year-old girl, and the oldest is a 14-year-old boy. These children currently right now,
3 months, not 3 years.
3 months. Thank you, Ms. Thomas. These children are currently residing with her mother and one cousin. And that child, 3 months, she had that child in prison, Your Honor. We are asking for a signature bond for Ms. Thomas. She would like to get back out, get back to her children, be able to see those children get back working. Again, they are in the care of her mother. However, Judge, she will be able to have employment once she is able to get back out because she was working with HelloFresh. She does believe she will be able to maintain or get back into employment, Judge. And we just wanted to discuss her history. We did hear about the Clayton County incident in 2019. However, when I spoke to Ms. Thomas, she informed me that her father had just recently passed and there was a lot of heightened miscommunication in that position. And that's when she caught those particular charges, Judge. But prior to that, her last interactions with the law, 2017, Judge, over 5 years. And so that's why I'm asking for that signature bond. And Judge, if not the signature bond, we're asking for that $4,000 surety, because that's effectively a no bond. She has no income right now and no one else to bond her out. Her mother is caring for her children, her family's caring for her children. And so we were asking for a modification to no more than $1,500, Judge.
Anything further, Ms. Mitchell?
Yes, Your Honor. The bond was set based on the bench warrant for her failure to appear. And it was set by Judge Porter, Patsy Porter.
Okay. And you're telling me, Ms. Helen, that she was in custody at that time?
Correct, Judge. Clayton County. November 2021, she was incarcerated in Clayton County.
Okay. Anything further, Ms. Mitchell?
Yes, Your Honor, we'd just like to reiterate that this was a situation where the defendant essentially ended up attacking a 17-year-old who she knew was 17-year-old at the time. Nothing further, Your Honor.
Okay, thank you. Ms. Helen, if you'll take it down, that I'm going to convert the surety bond to a signature bond through the jail. No further contact with the alleged victim. Ms. Passmore, abide by any stayaways that MARTA has in place. No drugs, no alcohol, no weapons while out on bond. Okay, you'll get that to the court. We'll get it signed.
And Judge, what's the breakdown? Or you're just changing it to a signature? Thank you, Judge.
Right. Okay. Good luck to you, Ms. Thomas.
Thank you.
Thank you, Judge. Thank you, Ms. Thomas.
Next, we have our last one, Your Honor. Thank you for your patience with me. Position 32, Ms. Woods.
Ms. Helen, I have this as a negotiated plea.
That is correct, Judge.
Okay. Good morning, Ms. Woods. I'm Judge Eric Moore. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Can you hear me, Ms. Woods?
Mm-hmm.
Yes, you're gonna have to answer yes or no for me.
Yes.
All right, and can you raise your right hand for me, Ms. Woods? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, ma'am. Ms. Mitchell?
Yes, Your Honor. Our plea offer is a time served for 16 days. Stay away from the Georgia Building Authority on 1 MLK Junior Drive, Southwest Atlanta, Georgia. Nothing further.
Yes, Your Honor. That is our understanding of the state's recommendation. We accept, we stipulate to the factual basis, venue, and ID.
Ms. Woods, it's my understanding that you wish to plead guilty to criminal trespass. Is that correct?
Yeah.
Are you under the influence of any drugs or alcohol this morning?
No other time.
Okay, you've been represented by counsel. Are you satisfied with her representation?
Yeah.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Mhm.
Is that a yes?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
All right, I'll accept your guilty plea as negotiated, Ms. Woods. Good luck to you, ma'am.
Okay.
Thank you, Judge.
All right, Officer Melton, I guess maybe I'll see you this afternoon.
Yes, sir. Thank you. Have a good
All
day.
right, you have a good morning also. All right, courtroom 2.
Good morning, Judge. I have before you position 18 through 21, Mr. Brandon Johnson. 18, 19, 20, and 21.
Okay, thank you. And this is going to be an arraignment and a bond hearing, is that correct?
That's correct, Judge. I believe Attorney Derek Howard is trying to enter the Zoom meeting. If the court can let him in, thank you.
Ms. Lewis, can you let Mr. Howard in? Are you going to need him for this case, Ms. Helen?
He'd like to sit on this case, Judge, yes.
On this one particular?
Yes, Judge, just to listen on.
All right, I just want to make sure. Ms. Lewis, can you just let me know if you received the request?
Mr. Howard is in.
Oh, okay. Thank you, Ms. Hill. Good morning.
Good morning.
Good morning, Mr. Johnson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Thank you. Mr. Johnson, you have been charged in case 21 CR 00009G with simple battery and battery against a female who is pregnant. In case number 21 CR 00013G, criminal trespass and simple battery family violence. In case 21 CR 00015G with battery family violence. And in case 21 CR 00019G with battery family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
Mr. Johnson, how do you plead to these charges? Guilty or not guilty?
Not guilty.
Okay, we'll record your not guilty plea, Mr. Johnson. Your case will be returned to the division judge and you'll get notification of your next hearing date. I have the bonds in front of me that were set by Judge Law on January 2nd of 2021 for the simple battery. For position 14, it's $2,500 cash. For position 15, it's $2,500 cash. For position 16, it's $2,500 cash. And for position 17, it's $2,500 cash. What's the history?
25 cycles. There's a 2011 simple battery that was no pros. One moment. I have a 2002 cruelty to the children conviction. All additional arrests after that conviction are driving offenses, unlicensed driver, Judge, nothing further.
So the last one was a 2002 cruelty to children?
Correct.
That's not me.
Okay, hold on, Mr. Johnson. Listen, you have a right to remain silent. Anything you say can be used against you. Okay, you have Ms. Helen as your attorney. Let her speak for you, okay?
Your Honor, sorry to cut in, but I think I heard you reference position 14 through 17. And I think Juan Johnson, who's position 18 through 21. I'm so sorry to interrupt. I was slightly confused too.
Okay, Mr. Walker, you're absolutely right. I was reading the number that's on the bonds. So the 14 through 17, they correlate through the 18, 19, 20, and 21. I apologize.
Okay, I'm sorry, yeah.
Okay, so they are still all $2,500 cash bonds on each charge, 18, 19, 20, and 21. All right, thank you. And who is representing for the state? You unmute, Ms. McCutcheon.
Yes, Judge. Good morning. Yes,
Okay,
Judge, I'll
good
be
morning.
handling these.
Okay,
the 4 cases.
you can proceed.
Judge, we would ask that the bond remain the same, the cash bond on each of the 4 cases. Each of these 4 cases, judges, are family violence cases, each dealing with alleged offenses committed by this defendant against the same victim. In 2 of the cases, the victim is alleged to have been pregnant. I also filed amended accusations in 3 of the cases, Judge, yesterday evening. I do not know if the clerk sees those amended accusations this morning, but those were filed yesterday evening. But based on the aggravated circumstances of all 4 cases and the same victim, and as I said, being pregnant on 2 of the incidents where the defendant is alleged to have physically struck her, assaulted her at one point in the presence of the child once the child was born, we'd ask that the bonds remain the same, that they remain as good cash bonds in each of the 4 cases. The state did make plea offers to the public defender's office yesterday in regards to 3 of these cases, Your Honor, which basically would have been a time served offer on 3 of them.
Okay. And there was no offer on position 21?
No, Your Honor, because if the defendant were to plead to the previous positions, then of course, by operation of law, position 21 would be a felony. If he were to plead to the 3rd case, which is a battery family violence, then the 4th case would go to the district attorney's office and to Superior Court.
And he has been in custody on these charges?
468 days, Judge.
For 462 days?
Yes, Judge. He was arrested on December the 31st of 2020, and he has been in custody since that time. He was not arrested on the previous cases until that date when he was booked in. And of course, at that time, he was booked in all of the cases. The cases having offense dates alleged to have occurred from December of 2019 through October of 2020. And then he was booked into the Fulton County Jail, as I said, on December 31st of 2020 for all of the outstanding warrants in each of the 4 cases.
Okay. Ms. Helen?
Yes, Your Honor. This is a bond hearing. Mr. Johnson is 41 years old. Currently, he is the father of 11 children. The age is ranging from 17 to 2 years old. He has 1 3-year-old girl with the alleged accuser, but he has fully 11 children that he is a primary caregiver of. He has recently been laid off due to the pandemic, Judge. However, prior to him being laid off, he worked in hospitality for several years, 4 to 5 years. He is a lifelong resident of Fulton County here in Georgia, graduated Douglas High School. His parents are lifelong residents of Fulton County. So addressing the Ayala factors, Judge, 1, I believe if released on bond, Mr. Johnson will come to all of his court dates. I do have an up-to-date address with Mr. Johnson of a 3831 Sunbridge Drive, Snellville, Georgia, 30038. When I spoke to Mr. Johnson about these cases, I brought up his history. These cases are back to back when Mr. Johnson is running into being arrested. And so when I spoke to him, I said, are you in any type of contact with this alleged accuser? He is not. There is no contact with Miss White. And I encouraged him to understand how serious these charges are, Judge. I understand that there are 4 open cases here. So when I spoke to him, he understands there is no contact with Miss White. There is a 3rd-party transfer with his kids, but Judge, he wants to be able to get out and be able to get back working and to be able to assist those children. Right now, he has a $10,000 cash bond. That is effectively a no bond. When I went back and investigated all 4 of these cases, Judge, there was a transfer request to the DA's office of January 11th of 2021. Mr. Johnson sat there waiting for a felony bond hearing and hasn't had one until today, Judge. He sat there for 468 days. Bond is not meant to be punitive. It's meant to give him an opportunity to get out, and he didn't have one. So while he was sitting there waiting for a felony bond hearing, nothing. I checked all of the events of those cases. There are no bond hearings. But all of them reflect there was a felony or a transfer to the DA's office. They transferred it back because they found out, they believed that there was another battery family violence in his history. There wasn't, and therefore they transferred it back, Judge, and he still sat there. So Judge, we are asking for a modification, firstly, of a signature bond for Mr. Johnson, because he erroneously sat in the Fulton County Jail waiting for a felony bond hearing to be heard on this issue. And it didn't happen. And then he was transferred back when they realized, oh no, he does not have a prior felony or a misdemeanor battery family violence in his history. So 468 days where bond has been held against him punitively because it's a cash bond that he can't afford. We're asking for it to be modified to a signature bond. If your honor feels that that is ineligible or he is ineligible for that signature bond, we're asking for it to be modified to no more than a $4,000 surety bond. That's $1,000 per each case, Judge, because effectively, again, he has no one else bonding him out. He has sat there that entire time, has no cash towards a $10,000 cash bond, and cannot afford a $10,000 bond even through surety. So that is why we're asking for a signature, Judge. And if not, then no more than a $4,000 surety bond.
Your Honor, if I might respond respectfully on behalf of the state. Of course, I do not know the details as to why the counsel for the defendant did not motion or move the court to have the defendant come before the Superior Court for a bond hearing, but that's not the matter before the court today. In each of these 4 cases, Your Honor, and 3 of these cases, the defendant was actually on, had an outstanding warrant. So he never came before the court because he fled from each of the locations we would expect the evidence to show prior to the arrival of the responding officers. And so he was at large until he was actually booked into the jail, apprehended and booked in December of 2020. Although counsel is stating that the defendant never came before the Superior Court for a bond hearing, once again, the issue before this court is whether or not this defendant is likely to re-offend, likely to intimidate the victim who is named in each of these 4 cases. And we would submit to the court that surely by the evidence of 4 cases being before this court, this defendant is likely to intimidate her and pose a threat to this victim. We'd ask the court to please keep the bond as set at the $2,500 cash bond for each of the 4 cases. If the court is so inclined to reduce the bond, Your Honor, I'd respectfully ask that the court not reduce the bond to anything less than $1,500 cash, which would be, I think, if I can calculate correctly, about a $6,000 cash bond for each of the 4 cases. But the state would vigorously ask the court to not issue a signature bond to this defendant who has shown that he is going to assault and intimidate this victim.
Okay, thank you, Ms. McCutcheon. Anything further, Ms. Helen?
Only, Your Honor, if there is extra conditions that can be added, an ankle monitor, if he's only able to go to work and back. My purpose, Judge, is for this person to be able to get out to his family after sitting for 468 days without that bond hearing and waiting for the opportunity to be able to be heard on this matter.
All right, so because of the seriousness of the charges, I'm not going to give him a signature bond. I will convert the cash bond into a surety bond. So if you will make those modifications, Ms. Helen, converting what's now a cash bond into a surety bond with all of the conditions that are on the bonds. Do you have a copy of the present bonds, Ms. Helen, or do I need to?
I do, Judge.
Okay, so if you'll make those modifications, then let me impress on you, Mr. Johnson, that if you do make these surety bonds, that you're not to have any contact with Ms. White whatsoever. And when I say no contact means no phone contact, no personal contact, no contact over email, no contact over social media, no contact, period. You understand me, sir?
Yes, Your Honor.
Okay.
Your Honor, might I ask, also add on behalf of the state that the court also ordered the defendant to not have any contact with the child, who is the child of both he and the named victim in these 4 cases, Semya White. Counsel for the defendant indicated something about a third-party transfer. Your Honor, unless and until the defendant has legitimatized that child in the Superior Court, we'd ask the court to order him to have no contact with either the mother or the child that he has with that mother, Semya White.
I do object, and I would object to a father being kept from their child. If there must be a legitimation process that's observed in order for him to be able to have a third-party visitation, that's understandable, but I would object to him being kept away from that child.
Your Honor, we don't know who the third person transfer person would be. There's no evidence before this court as to who that individual would be. And the state's very concerned about this defendant being in any circumstance where he is likely to encounter this victim, Ms. White.
I agree with you, Ms. McCutcheon. So at this point in time, although I'm going to modify the bonds, I want to make sure that he does not have any contact with Ms. White, whether it's inadvertent or not, through a third-party transfer. So at the present time, I will make sure that he does not have any contact through a third-party transfer.
Thank you, Your Honor. And respectfully, Your Honor, this concludes my business. May I be excused?
You don't want to stay with us, Ms. McCutcheon?
No, Judge, I have to go to a meeting, unless you need me, Your Honor.
It's always very pleasant seeing you.
Thank you. All right, good day. Good day, Your Honor.
Excuse me.
All right, Mr. Johnson, again, you have the right to remain silent. Anything you say can be used against you. Ms. Helen will have the opportunity to speak with you later today if you want to discuss things with her. Okay?
All right. I was just wanting to see what my bond would be.
All right, your bond is going, I believe it's going to add up to be a surety bond in the amount of $10,000.
All right.
Okay?
Thank you.
All right, good luck to you, sir. Who do we have next?
Your Honor, we have position number 10, Mr. Everett, position number 10.
And Mr. Finley, it's going to be a negotiated plea, is that correct?
That's correct, Your Honor.
Good morning, Mr. Everett. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me, Mr. Everett? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Ms. Tortorello?
Yes, Your Honor. This is the case of State versus Terrell Everett. Case number is 22 CR 001-758Y for the record. He's being charged for with simple battery, and the state is moving forward with said charge. The offer is 12 months served, 206 days. Credit for time served, 206 days. Balance probated, MHET, 40 hours of community service, no contact with the victim, and that's Dr. Will Powers. First name is W-I-L-L, Powers, traditional spelling. To stay away from Grady Hospital at 80 Jesse Hill Jr. Drive in Atlanta, unless for medical treatment. And relevant convictions, Your Honor. This defendant does have 32 cycles. Battery, he pled to on December 22nd, 2020 in Clayton County Superior Court. He pled to disorderly conduct and criminal trespass on July 24th, 2013 in Fulton State Court, Your Honor. And nothing further from the state.
Mr. Finley?
Yes, Your Honor. We do agree to the state's recommendation. We would just ask, Judge, that once Mr. Everett does complete the MHET and does complete the 40 hours community service, if his probation could be terminated, or if you're not inclined, if his probation could be not reporting, Judge.
Okay, I'll let it go to non-reporting, Mr. Finley.
Understood. Thank you, Judge.
Okay. Mr. Everett, it's my understanding that you wish to plead guilty to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this
Yes, sir.
morning? You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept your guilty plea as negotiated, Mr. Everett. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet.
All
And once you complete the terms of the probation, it is going to go to a non-reporting status, so you're not going to have to report, okay?
right.
All right, good luck to you, Mr. Everett.
Next, we have position number 6, Mr. Coleman, position number 6.
This is going to be a arraignment.
That's correct, Judge.
Good morning, Mr. Coleman. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Coleman? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. Mr. Coleman, you've been charged in case 22 CR 001739F with terroristic threats and simple assault. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead to these charges, Mr. Coleman? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, Mr. Coleman.
All right. Next, Your Honor, you have position number 2, Mr. Broussard.
Your Honor, I
Yes.
have an announcement for this case.
Yes.
Your Honor, this case has been accepted by the DA's office. I submitted the transfer order to Miss Middlebrook, so you should have it.
I do have it and it has been signed. So this will be an arraignment this morning.
Thank you, Your Honor.
Good morning, Mr. Broussard. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Broussard, you've been charged in case 22 CR 001754C with battery family violence. This has already been transferred to the DA's office. And given that the DA has accepted the transfer, it now becomes a felony case. So what I'm going to do is I'm going to wait for it to be transferred as he does not need to be arraigned here. Okay, Mr. Finley?
Understood, Judge.
All right, Mr. Broussard, your case is being transferred to the DA. You'll get notification of your next hearing date. Okay, sir?
All right, appreciate it.
You're welcome. Have a good day.
Next, we have position 15 and 16, Honeycutt.
Let's see, for position 16 was accepted by the DA. Is that right, Ms. Tortorella?
That's correct, Your Honor. I've
And
submitted the transfer order.
And what about position 15?
That's still in state court, Your Honor.
Okay. Good morning, Mr. Honeycutt. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Honeycutt. You've been charged in case 22 CR 001813J with 2 counts of battery family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead to these charges, Mr. Honeycutt? Guilty or not guilty?
Not guilty, Your Honor.
All right, we'll record your not guilty plea, Mr. Honeycutt. Your case will be returned to the division judge and you will get notification of your next hearing date. As far as position number 16, it's my understanding that this has been transferred to the DA's office and you'll get notification from the DA's office as to when your next hearing date will be for those charges. Have a good day, Mr. Honeycutt.
All right. Next, Your Honor, you have position number 22, Mr. Mayfield.
going to be a negotiated plea, Ms. Helen?
That's correct, Judge.
Good morning, Mr. Mayfield. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Mayfield? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Ms. Mitchell?
Yes, Your Honor, the state's plea recommendation is going to be 12 months to serve, 32 days confinement, credit for time served 16 days, balance probated, 6 weeks anger management course, no further contact with Jason Arnold Jr., to stay away from 2450 Old National Parkway, College Park, and 40 hours community service with no alcohol, drugs, and weapons. Nothing further.
Yes, Your Honor, that is our understanding of the recommendation. We do stipulate to the factual basis, venue, and ID. We just ask that his probation fees be waived.
Okay. Mr. Mayfield, it's my understanding that you wish to plead guilty to giving false information to a law enforcement officer in simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, I'm very satisfied. I just got a question.
Okay. Mr. Mayfield, you have a right to remain silent. Anything you say can be used against you. I'm happy to let you ask Ms. Helen a question if you have one, Ms. Helen.
Yes, Mr. Mayfield, if you have a procedural question, go ahead and give me a call. We can talk about it. But if it's about facts or anything like that, I advise you not to talk about that. What's your question?
It's about but will I get to get out today or?
So your release will be the jail. I told you how long it may take them to release you, right?
Okay, how long, what you said, 30 days?
About 48 hours, 24 if they're moving fast, 48, they're moving slow.
Okay.
All right. Any other questions you want before we move on, Mr. Mayfield?
Yeah, I just want to go over again with everything, you know, what I agreed to. I remember,
Okay.
I just want to make sure, you know.
Okay. So my last question to you was, are you satisfied with your attorney? And I think you answered yes. Is that right?
Yes, yes, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced you or coerced you to plead guilty?
No.
I'll accept the guilty plea as negotiated, Mr. Mayfield. I'm going to waive the fees for you while you're on probation. And when you complete the terms, it'll go to a non-reporting status, okay?
Okay.
All right, good luck to you, Mr. Mayfield.
Next, we have position number 17, Mr. Cal Hugh.
And this is the one that we need the interpreter for, is that correct?
That's correct, Judge.
And you've
Yes,
already.
I'm here.
All right. And Mr. Finley, do you need a breakout room or not before this, or can we just proceed?
Oh, we could proceed, Judge. I was able to communicate with him, but I just wanted to have a translator to make sure.
Okay, very, very good. Madam Interpreter, would you mind activating your
Yes.
camera for the court, please?
Yes, sir.
Thank you. Will you raise your right hand? Oh, thank you. Do you swear or affirm that you will translate from Vietnamese to English and English to Vietnamese to the best of your ability?
I do.
Okay, thank you, ma'am. Good morning, Mr. Hugh. I'm Judge Eric Morrow. This is the state all-purpose calendar.
Chào buổi sáng ông Hữu à, ông ta giới thiệu ông tranh án của Eric Moore. Dạ, ông ạ.
We're conducting this calendar today by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Ông có đồng ý hôm nay là mình ngồi cái mạng đó bởi vì cái virus đó, cái virus đó cho nên mình mới có cuộc họp. Ông có đồng ý hay không?
Yes.
Yes.
You've been charged in case 22 CR 001815 with possession and use of a drug-related object.
Ông bị phạt cái tội số của ông là CR 001815J là cái tội về ma túy. Ông có đồng ý hay không?
Can you raise your right hand for me?
Nhờ ông đưa tay phải lên ạ.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Những lời tuyên thệ của ông trong tòa án đây là sự thật và chỉ là sự thật. Ông có đồng ý hay không ạ?
Yes, sir.
Thank you. You can put your hand down.
Yes. Bỏ tay xuống ạ.
Ms. Mitchell?
Yes, Your Honor, this is going to be a time served plea, credit for 15 days, and a stay away from 700 Morosco Drive Northeast, Atlanta, Georgia. Nothing further.
Coi như là cô pháp viện mới báo là hôm bữa giờ ở trong tù, thì bây giờ đây là cái ngày được trừ ra và không có được đến cái nơi mà cô ta mới đọc được cái địa điểm đó.
Yes.
Yes. Mr. Finley?
And that is our understanding of the state's recommendation, of which we do agree.
Ông ta mới nói là lời công tố viên mới đọc ra cái sự quy tắc mới đặt ra cho ông thì ông ta đồng ý.
Yes, sir.
Yes.
Mr. Hugh, it's my understanding that you wish to plead guilty to possession and use of drug-related objects. Is that correct?
Ông Trinh Nắng mới hỏi là ông có đồng ý hay không? Hôm nay là ông tự nguyện có tội về dùng ma túy bất hợp pháp phải không?
Yes, sir.
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
Bữa sáng nè. No.
You've
He understood your
Okay. You've been represented by counsel. Are you satisfied with your counsel's representation?
Mình có hài lòng và cái sự giúp đỡ của dịch vụ của ông luật sư hay không?
Yes, sir.
Yes, I do.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Có hiểu hay không? Hôm nay là mình nhận tội là mình khuyết từ của cái gọi là ra tòa án á, xử án á. Có hiểu hay không? Nếu mà hôm nay mình nhận tội là mình không có xử án nữa, đúng hay không?
Yes, sir.
Yes, I do.
Has anyone forced you to plead guilty?
Có ai ép buộc mình hôm nay nhận tội hay không?
No, sir.
No, sir.
I'll accept the guilty plea as negotiated. Good luck to you, Mr. Hugh.
Oh, yes, sir. Thank you, sir.
Okay. Your Honor, that's the only case. May I be excused?
Yes, thank you very much. Have a good day.
Right.
You're welcome. Thank you, Your Honor.
Thank you.
Thank you.
Who do we have next?
Position 5, Cartwright.
Arraignment and a bond hearing, is that correct?
That's correct, Judge.
Good morning, Mr. Cartwright. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? You're on mute, courtroom 2.
Yes, Your Honor.
Okay. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, Mr. Cartwright. You've been charged in case 22 CR 001770A with battery, family violence, and terroristic threats. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead to these charges, Mr. Cartwright? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge, and you'll get a notification of your next hearing date. Mr. Cartwright, I set these bonds back on March 29th. Well, I set the bond. Did you all add another charge, Ms. Tortorello?
Yes, I added another charge, but I was planning to no pros that one as part of the plea offer.
So, all right. So, if he has terroristic threats, are you either I have to set a bond on that today, or you have to null pros that, which is the state going to do?
I would like to null pros that, Your Honor.
Okay, so if you'll submit the null pros to Ms. Middlebrooks, we'll get that signed. Again, for the battery family violence, I set the bond of $2,000 good bond on March 29th. Ms. Harrison, what's the history, please?
Cycles, last arrest September 2019, battery family violence in Fulton County. Last conviction I'm showing is, well, he has history also in Florida. And just the one cycle here in Georgia, Judge.
And that the other battery family violence, so he's before me for battery family violence. Does he have another battery family violence?
No.
No, okay. And I'm sorry, any other relevant history regarding violence?
No, Judge, his history is well beyond the 10-year period in Florida.
All right, thank you, Ms. Harrison. Ms. Tortorello, I see that your recommendation is 180 days, credit for time served 11 days. That seems excessive on a first-time battery family violence. Is there a reason?
Your Honor, they have prior difficulties. Not only that, Your Honor, she did admit that the last, because I don't know if you recall, Your Honor, but we had a case with him prior to this one where we did dismiss it. We could not locate the victim. She did talk to us and state that she didn't want to pursue that case. And this was where she was, the officer observed her, she had visible abrasions on her head and above her right eye. She also had blood pooling on her eyeball, Your Honor, for the prior case. So this would have been a felony, but for the dismissal, Your Honor. To add, Your Honor, the facts of the case, the fact that he struck her in the face with his cell phone, which resulted in her getting a laceration on her upper lip. He threw items at her, including a suitcase, a Lysol can, shoes, hot water. She did advise that the hot water stung, but she did not see any injuries due to the hot water. However, when we did follow up after SEA, she saw that she did receive bruises on her body due to the items that were thrown at her by this defendant, Your Honor. I understand it's his first time, but the facts are concerning, and that's why my recommendation is, as I've stated to opposing counsel, he hit her with a closed fist, and he's a multi-state offender. Given his record, Your Honor, he has battery history, but they've all been dismissed. He also has armed robbery in his history as well out of Florida. They may be just so far back, Your Honor, to even be considered. However, he has a history, and he, again, I just feel that my recommendation, I stand by my recommendation, Your Honor, for the offer.
Mr. Finley?
Yes, Your Honor. While I do recognize the seriousness of the alleged facts, they are exactly that, alleged facts. They are allegations. They are not fact. While I do recognize, the seriousness, and I appreciate those being read, I do like to point that out. Your Honor, as we also heard, he has no violent convictions. So while I understand that this would be a felony if that last case stood, that last case did not stand. So that is why we are here today, and it is a misdemeanor. Mr. Cartwright is relatively new to the Atlanta area. So he does not have anybody to pay his bond. So that is why he is sitting in here. I do understand Your Honor, did set a relatively low bond. The issue is he just doesn't have anybody that's able to pay it. He doesn't have anybody he can contact. So that is why he is sitting in there, and he will remain to sit in there. And that is why, Judge, we are asking for a signature bond on his behalf, Judge. Additionally, I did speak with Ms. Cartwright, and she is on the Zoom, I believe, and did want to speak on her husband's behalf regarding contact, Judge.
All right, Ms. Cartwright, if you are on the call, now is your opportunity to speak, if you would like to.
Can you hear me?
Yes, ma'am, you'll have to activate your camera for the court, please. Okay. Ms. Cartwright, can you raise your right hand for me? I think the other one's a right
Oh,
hand.
sorry.
That's all right. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. You can put your hand down. What would you like to tell the court?
I'm okay with the, I don't know what you call it, the no violent contact.
All right. Are you afraid of Mr. Cartwright?
No.
Okay. Well, apparently you were afraid of him enough on March 28th to call the police.
Yes.
So you couldn't handle the situation yourself? Is that what you're telling me? You needed the courts, you needed the police intervention?
Yes.
Anything else that you want to tell the court?
Nothing.
Okay. Thank you, Ms. Cartwright.
Okay.
I'm not going to let there be contact, Ms. Tortorella. So if you have anything that goes to contact, then there's going to be no contact. Okay.
Thank you, Your Honor.
All right. What I will do is I will convert the good bond to a $5,000 signature bond through the jail. No further contact with Sherry Cartwright. Mr. Cartwright, when I say no contact, this is for both of you all. When I say no contact, I mean absolutely no contact. No phone contact, no personal contact, no social media contact. If I find out that that there's been any contact whatsoever between the two of you all, then this bond is going to be immediately revoked. Do you understand what I'm saying, Mr. Cartwright?
Yes, sir.
All right, you just stay away from the 3248 Verdant Drive, number 801 location. You can go back to that location on one occasion with law enforcement to retrieve any belongings that you might have there. You have no alcohol, drugs, or weapons while out on bond. All right, so I'm giving you the opportunity to get out, Mr. Cartwright, but if you violate this bond, you won't be given a second chance. You understand?
Yes, sir.
All right. Good luck to you, both of you, Mr. and Mrs. Cartwright.
Thank you.
You'll get that modification to the court, Mr. Finley?
Yes, Your Honor, I will. And just want to verify, Judge, that was $5,000 signature bond through the jail?
Yes.
Okay.
Okay.
Thank you, Judge.
All right. So who do we have next? Ms. Tortorella and Mr. Finley?
Position 7, Mr. Cox.
Okay, thank you. Circling back to that, to the case where we had the restitution. If you all can agree on that before hearing, you know, if Mr. Finley, if Ms. Tortorella provides you with the information that you're satisfied with, we don't have to have a hearing if you want to.
Okay.
Okay. So
If we, yeah, we could. I just want to, obviously,
Okay, so it'll be back on the calendar if you want it to be. If you want to
No.
have a hearing on it, but if you can agree on it, then we don't have to have a hearing, okay?
No, completely understood. I want to make it as easy as possible, Judge and Sue. I just want to get the defendant obviously to agree to.
Sure, no, I understand you have to do what you
Understood.
have to do, but,
No, completely. That would be
Okay.
easiest, and I want to make sure that's
okay, I just wanted to remind you all of that.
understood. Thank you, Judge.
Thank you, Your
All
Honor.
right, so I'm sorry, courtroom two, who do we have?
Position 7, Mr. Cox.
Okay. And I have a conflict attorneys representing, do we know who's representing Mr. Cox? Ms. Lewis, do we know who's representing Mr. Cox?
Let me follow up on that. Give me 1 second.
Okay, can we go to someone else? A conflict attorney is representing Mr. Cox. It doesn't appear that we have a conflict attorney present at the present time. So can we go to someone else?
Mr. Young, position 33.
Okay, thank you. A negotiated plea, Ms. Helen?
That's correct, Judge.
Good morning, Mr. Young. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Judge.
Thank you, Mr. Young. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Ms. Mitchell.
Yes, Your Honor, the state's plea recommendation is going to be 12 months to serve, 32 days confinement, credit for time served 16 days, balance probated, no further contact with Lloyd, spelled L-O-Y-D-D, Hewley, stay away from 609 Cascade Avenue Southwest, Atlanta, Georgia, 8-week anger management, and 40 hours community service, along with no alcohol, drugs, and weapons, nothing further.
Yes, Your Honor, that is our understanding of the recommendation. We accept and we do stipulate to the factual basis, venue, and ID.
Mr. Young, it's my understanding that you wish to plead guilty to battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea as negotiated, Mr. Young. I'm going to waive the probation fees while you're on probation to help you get and stay on your feet. And once you complete the terms of the probation, then it'll go to a non-reporting status, okay?
Yes, sir. Thank you.
All right, good luck to you, Mr. Young.
Thank you, sir.
Judge Morrow, apparently,
Yes.
we were not aware there was a conflict attorney for this case because the co-defendant was released. And I don't think the state, not the state, but the PD did not request a conflict defendant on this case because these cases were newly accused. They were not like on an SEA count or nothing at that point. So we were not aware of there would need to be a conflict defender present today.
Okay. So he has not been assigned a conflict attorney as of yet?
We were not aware there was supposed to be one because apparently the co-defendant was released and these are brand new cases. They were never on an SEA counter.
Okay, so I'm just saying that we don't have anyone that's
No,
already.
not at this time.
Okay, so that's my point. Can I get Mr. Cox back up here, please? Can I see his bond? Mr. Cox, it's my understanding that you were supposed to have a conflict attorney represent you on this theft by shoplifting charge. We do not have a conflict attorney present. I know that, may I see it? I'm sorry. Okay. If you did have a conflict attorney present, then he or she would have let you know that it was going to be a time served plea today. I'm going to take a look at your bond to see what your bond is, and do we know if he's been? Okay. But still, he should have. March 29th, he was arrested. Has he been, it is April 12th now. Has he been sitting in jail without a bond on this charge? Is he in jail for something else? Well, he still should have come before somebody for a bond hearing regarding this theft by shoplifting.
Your Honor, what I see is that he has a $5,000 surety bond on this charge.
Okay.
Because this was a bond over case. It was bond over from another jury district. That's the reason. why.
Oh, okay.
He already had a bond that was set, and then he was transferred to the Fulton County Jail. From understanding that the state accused the charge.
Okay. Thank you, Ms. Lewis. Do we have his history, Ms. Harrison?
27 cycles. He has a 2016 misdemeanor conviction, theft by shoplifting in Cobb County. A 2015 Clayton County conviction for theft by deception. A 2014 identity theft fraud. That was, let's see, 2 years confinement and 8 years probation. And also forgery in the 4th degree out of Coweta County. A 2012 criminal trespass, Fulton County. And that's the past 10 years.
Okay, so nothing says 2016?
Correct.
Let's see, Mr. Finley, can you assist me on this, please? I don't want Mr. Cox, given that he was going to get a time served plea today, to be sitting in jail on a $5,000 surety bond on his theft by shoplifting. I'm going to convert it to a $3,000 signature bond through the jail, and he's to stay away from all Walmarts in Fulton County. Can you prepare that for the court, please? Is that possible?
Yes, Your Honor. Could you just, if you don't mind, if you could state that one more time, what it's going to be changed to?
$3,000 signature bond through the jail, and stay away from all Walmarts in Fulton County. So if you can unmute courtroom 2. Mr. Cox, we don't have an attorney present for you today. I've taken a look at your history along with this charge. I'm reducing your bond to a signature bond so that if you don't have anything else holding you in jail, you're going to be able to sign yourself out, okay?
Okay, thank you so much.
All right, now you know you can't go back to a Walmart, okay?
Yes,
So stay away from the Walmarts.
definitely we.
Okay, all right. Good luck to you, Mr. Cox.
Okay, thank you.
Thank you. And I appreciate that, Mr. Finley.
Yeah, I'll prepare that. No
Come on,
problem.
Mr. Bullock.
Thank you. Who do we have next?
Mr. Bullock, position 3.
Good morning, Mr. Bullock. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. I've got, this is a negotiated plea.
That's correct, Judge.
How long has he been in custody?
He's been in custody. Sorry, let me pull it back up.
Maybe a little over 130 days. Your
Yeah, I
Honor.
was going to say, I think it's close to 140 days or something. I'm going to double check though.
Is something else holding him in?
He has a judicial hold, Your Honor. It's a felony case, 19 SC 167057. Incident date, April 2nd, 2019. Aggravated assault and possession of firearm during a commission of certain felonies.
Okay, and
Yeah, it's been
all right.
131 days, Judge. It's been 131 days he's been in. If you remember, I previously tried to do a non-negotiated plea and tried to get less time for Mr.
Okay.
Bullock. So I've been in front of the court a couple times and we've tried to modify bond, tried to get reduced time, and that's why we're here. Yeah.
Okay, all right. Ms. Tortorella,
Yes, Your Honor, my understanding is this is a negotiated plea. This is State versus Milwaukee Bullock, case number 22 CR 000059J for the record. State's offer is 12 months to serve. However, giving him credit for the 130 days served. And relevant convictions on December 17, 2019, he pled, it was a robbery reduced to disorderly conduct at a DeKalb County Superior Court. And nothing further from the state, Your Honor.
Mr. Finley?
Yes, Your Honor. I did speak with my supervisor, Derek Howard, and we do agree to the 12 months to serve. It is our understanding and hope that he will get the 2-for-1, which would be about 182 days. And if he's served 131, obviously not too much left. So we are obviously hoping that he will get the 2-for-1 judge. But we do agree to the state's recommendation.
Okay. So it's 12 months to serve, 365 days, credit for time served, 131 days. Balance suspended. Is that right?
Well, Your Honor, I don't believe there would be a balance.
No, it's 12 months to serve. We're giving him credit for 130 days.
Right, so you were correct. It's 12 months to serve, 365 days, credit for time served of the 132 days, but there is no balance because he's.
All right.
Yeah.
So he'll be in the, yeah, okay. Anything further?
Nothing
But-
further from the state, Your Honor.
So it is up to the jail, obviously, but we think he will be the 2-for-1, I'm assuming, for 182 days. Is that correct?
That's the way the jail normally does it.
Okay.
All right, so Mr. Bullock, it's my understanding that you wish to plead guilty to carrying a weapon without a valid license. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I will accept your guilty plea as negotiated, Mr. Bullock. Good luck to you.
Thank you, Your Honor. Mr. Finley, can I speak to you real quick about something?
You can give him, Mr. Finley, can you
Yeah.
give him a call after court today?
Yes.
Okay, so he'll speak with you, Mr. Bullock.
Thank you, Mr. Bullock.
Position 12, Gibson.
Good morning, Mr. Gibson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Gibson? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. Ms. Mitchell?
Yes, Your Honor, our recommendation is going to be time served, credit for 15 days, a stay away from the racetrack on 2645 Old Milton Parkway, Alpharetta, Georgia. Nothing further, Your Honor.
Mr. Finley?
Yes, Your Honor, that is our understanding of the state's recommendation, of which we do agree, and additionally stipulate the factual basis, venue and ID.
All right, Mr. Gibson, it's my understanding that you wish to plead guilty to obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you to plead guilty?
No.
Okay, I'll accept the
Hold on,
Guilty plea as negotiated, Mr. Gibson. Good luck to you.
Yes, sir. Thank you.
You're welcome.
hold on. Position 14, Mr. Ham.
This is going to be a non-negotiated plea.
That's correct, Judge.
Good morning, Mr. Ham. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Appreciate it.
You're welcome. Can you raise your right hand for me?
Yes, sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Let me go ahead and get the history since this is non-negotiated. Ms. Harrison, please.
Yes, Judge, 46 cycles with history in Pennsylvania, Delaware, and Florida. One moment.
Did it freeze?
I have a 2015 conviction for theft by shoplifting and a removal or attempt removal of weapon of public official felony and a willful obstruction felony in DeKalb County. A 2000 and that's the only arrest he has here in Georgia, Judge.
Okay. So nothing since 2015?
Yes.
Okay, thank you. Ms. Tortorella?
Yes, Your Honor. The state's gonna go ahead and move forward with the battery, family violence, and simple battery family violence charges. Our offer that we conveyed to opposing counsel is for the battery family violence is 12 months served, 60 days, credit for time served, 13 days, balance probated, no contact with the victim, to stay away, family violence intervention program, and 40 hours of community service. And then the simple battery family violence will merge with the first count. Given that this is a non-negotiated plea, I'm going to go ahead with the facts, Your Honor. On March 22nd, 2022, around 1:18 a.m., an Officer S. Tran of the Atlanta Police Department responded to a domestic violence dispute call at 835 Rose Circle Southwest in Atlanta. Upon arrival, the officer spoke to the victim, Robert Connor, who said he stays in the apartment number 4 and was trying to get some sleep. But his next door roommate, defendant Kenneth Ham, was making a lot of ruckuses. There was an argument between the two parties. The defendant became upset and pushed the victim into his room and then got into a physical altercation. The victim advised the defendant pushed him and then that he fell on his bed. And due to him defending himself, the victim found the nearest object to throw at the defendant. The victim was punched in the face. The officer observed a knot on his left temple and a knot on his top left side of his forehead. And all these events did occur in Fulton County, Georgia, Your Honor. And just to add, the relevant conviction that I see on his records for the obstruction felony and the theft by shoplifting, which he pled to on June 23rd, 2015 in DeKalb County Superior Court, and nothing further from the state.
Mr. Finley?
Yes, Your Honor. I am asking for time served on behalf of Mr. Ham. As of now, with the offer, he would be serving 17 additional days. Mr. Ham has been walking a straight line since 2015. He told me that since then, he has made a point to go to the gym. He goes to LA Fitness about 6 times a week. works out. He does odd jobs. He has a couple people that give him lots of different tasks to do, and he works out, saves money, and this was just his roommate. This alleged incident, this was just his roommate. He has no interest of having any types of communication with them. He did say it was self-defense, Judge, so we do not stipulate to the facts. He says he was defending himself as well. So the facts are, I think, a little bit murky, as Mr. Ham did have a noticeable black eye as well. And this was incident was a little while ago, and I could still see some damage on his face. So on behalf of Mr. Ham, Judge, we are asking for the time served. And additionally, that once he does complete the community service and the family violence class, if his balance could be either terminated or not reporting, Judge.
Okay, a couple of things, Mr. Finley. Either he's pleading guilty and admitting to the facts of this, or he's not pleading guilty. So I didn't understand your recitation in the sense that it sounded to me as though that he was not interested in entering a guilty plea.
No, I mean, Your Honor, he stated he did want to plead guilty. He just said when we talked about the facts of this, he's, didn't agree that's exactly how it happened. But he did want to plead guilty, Judge.
Okay.
If that's, if that's what Mr. Ham, I left the decision up to Mr. Ham. That's just what he stated. He said that's not exactly how it happened, but he did want to plead guilty, Judge. That's what he stated.
Right. And you did not, your only objection seems to be with the jail time. You didn't have any objection to the stay away and to the no further contact.
That's correct, Judge. Yeah, he already has another place to stay lined up.
I have to get my stuff now. I gotta go back to get my phone and stuff like that.
Okay, I'll allow you to have a escort, Mr. Ham. All right. Anything further?
Your Honor, I just wanted to state that it's based on the facts. The officer did not observe a black eye on the defendant. He did observe lacerations on his hands and feet. But just to put that on the record.
Medical report on me in the hospital.
Oh, hold on, Mr. Ham. Mr. Ham,
Mr. Ham.
You have a right to remain silent. Anything you say can be used against you, sir, okay?
I'll speak for you, Mr. Ham. And I appreciate that, Ms. ASG. I'm just reporting what I saw when I visited with him yesterday. And he just had some blue under his eye that he did not have on the other eye.
Okay. Mr. Ham, it's my understanding that you wish to plead guilty to battery family violence. Is that correct?
Mr. Ham, the decision is fully.
I wanted to go what you originally said with me. I shouldn't. I might reconsider taking the guilty plea.
Okay.
They offered too much for me. It's not right. I feel I'm innocent. I really wanted to get this over with.
All right. Okay. So I'm not going to allow you to plead guilty today, Mr. Ham, because I get an understanding that you don't. What's the bond amount in this case?
I apologize for Mr. Findings. I'm sorry.
No, Mr. Ham, you don't need to. This is like I went over with you yesterday. This decision is completely 100% yours. Yes, sir.
Your
Mr.
Honor, I'm sorry.
Ms. Tortorella, go ahead.
You asked about the bond amount. It's a $2,000 surety bond, Your Honor.
Yes, I set this bond back on March 28th at the SEA calendar. Given what I've heard today, given the history and what I've heard from counsel and revisiting the facts and the history of this case, take this down, Mr. Finland, if you wouldn't mind.
Yes, Judge.
I'm going to convert the $2,000 good bond to a $2,000 signature bond through the jail. No further contact with Robert Connor. Stay away from the 835 Rose Circle address. He can go back there on one occasion with law enforcement to retrieve any belongings, and no guns, alcohol, weapons while out on bond. So, Mr. Ham, I'm going to allow you to sign your own bond to get out, but you'll have to come back to answer for these charges at a later time, okay?
I appreciate it, sir. I found another place to live. I'll be moving. I just
Okay,
need to get my stuff. That's it. I appreciate it.
all right. You're welcome. Good luck to you, Mr. Ham.
Thank you, sir.
Thank you,
Your
Judge.
Honor, can you repeat the bond amount again? I'm sorry.
I'm just converting the surety bond to a signature bond through the jail. It's $2,000 with all the other conditions that were on the previous bond.
All right, thank you, Your Honor.
Oh, right. So, so the simple battery was to merge into the battery family violence. Did you add the simple battery at a later time, Ms. Tortorella?
Yes, Your Honor, I did.
Okay, so do I need to set a bond for that, or are you going to null pros that?
I won't null pros that, Your Honor. We could do
Okay.
$1,000 for each if you prefer, Your Honor.
Yeah, and that'll be fine. $1,000 signature bond for each charge, Mr. Finley, okay?
Got it.
Just-
Thank you.
Okay, thank you for pointing that out, Ms. Middlebrook, so that he's not sitting in jail. All right, good luck to you, Mr. Ham.
Thank you, sir.
You're welcome.
Position 23 and 24, Palmer.
I believe he's also position 25, Your Honor.
Okay.
Yes, also 25.
Okay. Good morning, Mr. Palmer. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me, Mr. Palmer? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you. Mr. Palmer, you've been charged in case 17 CR024074A with battery family violence, and case 22 CR001816E with simple battery family violence, and in case 16 CR006054A with simple battery family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusations, Ms. Helen?
I do, Judge.
How do you plead to these charges, Mr. Palmer? Guilty or not guilty?
Not guilty.
We'll record your not guilty pleas. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Do you have this? Thank you. The bond was set on March 30th. Well, the bond for simple battery family violence, 1816E, was set on March 30th. That's a $2,500 good bond. The simple battery family violence is a $3,500 surety bond, and the other charges are $3,500 good bond. Ms. Mitchell?
Yes, Your Honor, for position 23, I have a $7,000 good bond. For position 24 is $2,500 good bond set by Judge Williams. And then for position 25, I have a $1,500 surety bond. Well, good
Correct,
bond.
Judge. That's what I have as well.
Okay. All right, go ahead, Ms. Mitchell.
Okay, so I'll just start in chronological order of the offense dates. So that I can paint a better picture. Your Honor, on August 29th of 2014, the defendant battered his wife, Miss Crystal Palmer, by punching her in the side while she was 8 months pregnant at the Hamilton E. Holmes MARTA station. The defendant got angry because Miss Palmer gave a $5 bill to a person at the McDonald's located on 2442 MLK Jr. Drive. While the defendant was detained and in the back of the patrol car, he called Miss Palmer to the window of the patrol car to speak to her. That's when he stated to her that he was going to kill her when he was released from jail. On that case, he has a $1,500 surety bond. He was originally given a $2,500 surety bond, so they reduced it. The defendant FTA'd on this case at his status conference on May 24th of 2021. Then on the next case, on September 24th of 2017, the defendant battered his wife, Miss Palmer, again by grabbing her by the neck and choking her in the parking lot of their home. Miss Palmer stated that nothing happened between them when he started strangling her. The smell of alcohol was present on his breath at the time. The 911 call was made by a passerby who saw the defendant with his hands around her neck of Miss Palmer, and he saw Mrs. Palmer trying to fight the defendant off of her. On this case, he was given a $7,000 surety bond. Originally, he was given a $2,500 surety bond, but then he FTA'd on this case several times because he was then later given a $3,500 surety bond twice. So he FTA'd on a plea and arraignment in April 11th of 2018, and then he FTA'd on plea and arraignment on September of 2018, and then he FTA'd at a status conference on May of 2021. Then our most recent case on March 29th of this year, the defendant battered his wife, Miss Palmer. As you can see, Your Honor, it's the same victim in all the cases. He battered her by punching her in the face in front of the BP gas station. Miss Palmer had a black eye, but stated to the officer that it happened a week ago, and she never called 911 regarding the incident. And she stated to the police that the abuse is an ongoing issue between them. And in this case, he was given the $2,500 surety bond. Your Honor, as I've already stated, it is the same victim, his wife, in each of these cases before the court today. The defendant has a violent history. Not sure, did pretrial go over that? I can go over the.
Okay, if you'll just go over it, Ms. Mitchell.
Yes.
If you like.
So his convictions, he has 2 simple battery convictions and 1 simple assault. All of them are in the 1980s. However, he does have egregious charges that he wasn't necessarily convicted of. They were no pros, but I can list those out because it does show a pattern. Kidnapping and aggravated assault and battery in 2012, simple battery, family violence in 2012, simple battery, family violence, battery, and kidnapping again in 2011, 2 charges of battery in 2010, and then 3 counts of simple battery, all in the 90s. We do have serious concerns of witness intimidation in this case. Our victim advocate had an opportunity to speak with Mrs. Palmer, and she stated that they've been married for 38 years and they've all lived together. She stated that the defendant has been abusive at least 3 or 4 times in the past, and that when she tries to call the police on him, the defendant will hide her phone. So we have serious concerns for the victim in this case. The defendant has shown a pattern that he's not afraid to abuse her, and he's going to continue to abuse her no matter how many times he's been arrested. We are also concerned that the defendant is a flight risk. He does have 5 failure to appears. And based on our records, the defendant is currently listed as homeless. So based on our history, we're concerned that the defendant is going to go back, if let out, that he's going to go back to the home he lives in with Miss Palmer and abuse her again. So based on that, the state is recommending that the bonds remain the same on each of these cases. Nothing further, Your Honor.
Thank you. Ms. Helen?
Yes, Your Honor. This is a bond hearing today. Mr. Palmer is 56 years old. I'd like to just get into the Ayala factors because yes, he is residentially challenged. So I'm just a little confused about the recitation of the events between this alleged accuser, Mr. Palmer, at their house, in the parking lot in front of their house. They are residentially challenged. He's been homeless for several years. Also, speaking a little bit just as far as his history, again, the charges that are null pros, if the state did not feel that they were worthy to prosecute, I don't understand why they would be held against him today. And if the last ones are in the 1980s, Judge, that's why we're asking for a signature bond for Mr. Palmer. When I spoke to him, this alleged accuser does suffer from some diagnosed MH issues. Again, just putting that information out there to where she will call the police and abuse their policing power towards Mr. Palmer. He understands that there is a stay away from her currently. She does not. She contacts him at the jail. She's trying to reach out to him. He's trying to get away from this individual because when they get close, apparently she calls the police during a mental breakdown, Judge. And so that is why I'm asking for Mr. Palmer to be granted a signature bond. He understands there's no contact with this individual. He wants no contact. She is reaching out to him. He was also afraid she may even try to show up today to, again, try to gain more contact to him. He wants none. So Judge, we are asking for a signature bond. If not a signature bond, we're asking for a total bond, no more. Again, it's all a no bond. Again, Mr. Palmer has no income. He's been residentially challenged for years. And so when I spoke to him, he said they were not living together. They have no home. He's transient. There is no location that he lives or shares with this individual. He's not a flight risk because he's resided in the state of Georgia for the last several years and has been homeless here for the last several years. Witness intimidation, he doesn't want any contact. This person is reaching out to him. He even asked me, how do I get a temporary restraining order against her to stop her from contacting me? He's no danger to the community. I didn't hear allegations of harassing people in MARTA or anywhere else. And again, reoffending. This is, his last was the 80s. And then some other charges were null pros. This is not a danger to the community. These are not dangers to other individuals. He wants to stay away from this person. She is not allowing him and she's suffering from some other issues. So Judge, I'm asking for help to get Mr. Palmer out, to get these cases underway because he is pleading not guilty, but he wants to be able to get out and be able to readjust his life. Because again, he's been residentially challenged and these cases, as he's been incarcerated, is not helping him, Judge.
And Your Honor, if I may say something.
Ms. Mitchell, I'm not going to change the bond, so you can, I don't mean to interrupt you, but Mr. Palmer's been given ample opportunities. He's FTA'd numerous times. There continue to be allegations, so I'm going to leave the bonds where they are. I'm sorry, Ms. Mitchell, I didn't mean to interrupt you, but.
No, you're fine.
Okay.
Thank you.
All right, Ms. Helen, I understand your argument, but he's just FTA'd too many times on these charges. And I can't risk that he's going to get out again. And even if what you say it's taken as true, you know, I don't want him. He's been back around or she's been back around him and there are other allegations. So at this point in time, I'm not going to modify the bonds. Thank you.
Did you hear that, Mr. Palmer? The judge is not going to modify the bond, okay?
I'm out of sitting jail.
Say it again, Mr. Palmer.
How long I'm gonna be in jail?
Well, until you can bond out, Mr. Palmer, until your cases go to trial.
When will the trial be set?
We can discuss those details. If you can give me a call, they can give you the phone and we can talk about that.
I don't need to have your phone number. I don't need to know your phone number.
They have my phone number, Mr. Palmer. So if you'd like to take a moment, we can talk.
Hold on, Ms. Heller. I'm being told that he needs to be arraigned on one of these cases. Which cases? Position 24. All right. I'm sorry, Ms. Palmer. Let me go ahead and arraign Mr. Palmer. And he's already been sworn in, and this is on position 24, the simple battery family violence. Mr. Palmer, you've been charged in case 22 CR 001816E, simple battery family violence, a charge that occurred on March 29th of 2022. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
Mr. Palmer, how do you plead to that charge, guilty or not guilty?
Not guilty.
Okay, we'll record your not guilty plea, Mr. Palmer. Good luck to you, sir. And you'll be in touch with, Ms. Helen will be in touch with you, Mr. Palmer.
So,
who do we have next?
Position 4, Kane.
Good morning, Mr. Kane. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
yes, sir.
Thank you. Mr. Kane, you've been charged. I'm sorry, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. Put your hand down, Mr. Kane. Ms. Tortorella?
Yes, Your Honor. So this is case number 17 CR 025842Y for the record. The state is offering 12 months served 46 days, credit for time served 23 days, balance probated, 40 hours of community service, family violence intervention program, no contact with the victim. Her name is Kasia Kane. That's spelled K-E apostrophe Asia, like the continent. Kane is spelled C-A-I-N-E. To stay away from 1670 Alvarado Terrace. Alvarado, for the record, is A-L-V as in Victor, A-R-A-D-O. Terrace Southwest, Atlanta, Georgia, 30310. And he does have a relevant conviction. He pled to simple battery on April 22nd, 2014 in Gwinnett County Superior Court. And nothing further from the state, Your Honor.
Mr. Finley?
Yes, Judge. We do agree to the state's recommendation, Judge. We would just ask that once Mr. Kane does complete the 40 hours community service and the FVIP course, if he could either be, or if the balance could be suspended or not reporting, Judge.
Your Honor, the state will object to that. He has an open felony case, 22 DA 01557, for theft by shoplifting, incident date of September 21st, 2021. He also has a record of parole violation. Due to this incident, Your Honor, for this case, he violated his parole. So for that reason, the state does ask for him to remain reporting, Your Honor.
I'm going to have him report, Mr. Finley, and I'll waive the fees, but he's going to have to report the entire time.
Understood, Judge.
Okay. Mr. Kane, it's my understanding that you wish to plead guilty to battery family violence. Is that correct?
Yes, sir.
You have to speak up for me, sir.
Sir.
Yes?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir. No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
Is that a yes?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the guilty plea as negotiated. Mr. Kane, I am going to waive the fees, the probation fees while you're on probation to help you get and stay on your feet, but you're going to have to report the entire 12 months, okay?
Yes, sir. Thank you.
All right, good luck to you, sir.
Position 26 through 30, Mr. Soretto.
And this is a non-negotiated plea, is that correct?
That's correct, Judge.
Your Honor, if I may ask P.D. Helen, for position 29, we offered time served. Are you still saying jail time's an issue on that position? Because if not, we can go ahead and do a negotiated plea for position 29 and address the other issues.
Nope, that's not an issue. Just 26, 27, and 28.
And 30.
Correct.
Good morning, Mr. Soretto. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Can you hear me, sir? Is courtroom 2 frozen?
They might be.
Courtroom 2? Okay. Are you back with us, courtroom 2?
I'm just asking them to unmute themselves.
Brittany saying,
Okay. Can you hear me, Mr. Soretto?
yes,
Okay. Good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
yes, sir.
Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Let's see, can we go ahead and get his history to start off with, please? Pre-trial, oh, there you go, Ms. Harrison.
Judge. 5 cycles. Last arrest, May of 2019, battery, family violence, first offense, cruel to children, 3rd degree in Roswell, Georgia. That's actually this case, Judge. As a 2005 theft by shoplifting, nothing further.
Ms. Mitchell?
Yes, Your Honor, I'm just gonna go in chronological order of the position numbers. So on position 26, on May 19th of 2019, the defendant battered his girlfriend at the time, but now his estranged wife and mother of his children, Miss Martha Bazan, spelled B-A-Z-A-N. She also goes by Martha Quinones, spelled Q-U-I-N-O-N-E-S, but we'll refer to her as Ms. Bazan for the purpose of this proceeding. By grabbing her and dragging her out of the car and dragging her approximately 50 feet from the car to the parking lot, through the parking lot. Your Honor, this left multiple abrasions on Ms. Bazan's ankle and on the back of her arm. It started when the defendant got upset because Ms. Bazan tried to take the car to go to the pool with Ms. Marisol Lopez Reyes and several small juveniles. And I believe one of them were a child that they had together. Your Honor, in this case, the defendant FTA'd on his status calendar on October 26th of 2021. Moving on to position 27, in the criminal trespass family violence case. In this situation, on March 18th of 2022, Roswell PD responded to a domestic dispute call. They were met with the victim, Ms. Bazan. But upon their arrival, Ms. Bazan couldn't open the door, and the officers were able to see the visible damage from forced entry that was done to the door and a visible boot print with mud on it. Ms. Bazan informed the officer that the defendant is her husband, but they don't reside together together and that he's estranged. And that he became upset after he texted her, but she fell asleep and was not answering. That's when the defendant came to the home and beat the door down, and she called the police. Moving on to the next position on 28. In this criminal trespass family violence case, the defendant damaged the door to Ms. Bazan's home again, located on 205 Holcomb Bridge Road, by beating the front door and causing the deadbolt and the frame of the door to become unhinged. That's when Ms. Bazan informed officers that the defendant was living in the woods behind her home. On position 30, on November 21st of 2019, Roswell PD responded to a harassing communication call, and Ms. Bazan informed officers that the defendant repeatedly called and texted her with harassing and threatening messages. The defendant was located in the woods after Ms. Bazan informed the officer that he was living in the woods behind her home. Officers located the defendant in the woods, but the defendant began to flee, and officers weren't able to make an arrest at that time. So, Your Honor, our plea recommendation is going to be a consolidated plea recommendation on positions 26, 27, 28, and 30. And we're recommending 12 months to serve, 180 days confinement, credit for time served 64 days, balance probated, no further contact with Ms. Martha Bazan, a stay away from 205 Old Holcomb Bridge Way, Roswell, Georgia, and 621 Creekside Way, Roswell, Georgia. That was the address in the other criminal trespass case. We're not sure who that home is. But we just want to make sure that when Ms. Bazan is there, he does not try to break down that door as well. A third-party transfer of their children, FFIP course, 60-hour community service, and no alcohol, drugs, and weapons. Your Honor, we'd like to note that during the SEA calendar on his most recent case, the defendant, Ms. Bazan, stated that the defendant has caused her and their family a lot of pain and that she does not want any contact with them. The defendant was seen trying to talk to her through the Zoom on SCA that day and was telling her to tell the truth and don't lie in Spanish. So we do have concerns of witness intimidation in this case. Nothing further, Your Honor.
Ms. Mitchell, on these bonds, let's start with or on any of these bonds, was there a no further contact order on the bond?
Your Honor, can I get a moment to double check on that for?
Yes, because if there was, then he would have been in violation of that or those bond orders, and I need to know that. Okay?
Yes, Your Honor.
So while you do that, Ms. Helen?
Yes, Your Honor. So I have Mr. Serrato here today, and so far he's done 64 days of confinement. We don't have any disagreement with the conditions of the FFIP course, the probation, the 60 hours of community service, no drugs, weapons, or alcohol, and specifically the stay away from Miss Martha Bazan Quiones. When I went and spoke to him, again, I thought that there may have been a breakdown of communication, but we got clear that there is no contact with her. He understands, yes, Your Honor, they are currently married. They do share children. However, due to these cases, that there is a current no contact with her and a stay away from those addresses. That's why he has updated information of a different location that he's going to reside with. One of his friends, Roman, we also have his contact information. I also have the contact information of his boss, Claudius, that works at is the owner of the car dealer or the car shop that he works with, who also is supporting Mr. Serrato. So Judge, that's why we're asking for the 64 days to be considered time served. We have no disagreements with the conditions. He's willing to do all of the conditions, and we want to highlight and stress, which I did to Mr. Serrato, there is no contact with Miss Martha Bazan, and that there will be a third party either transfer for visitation with the children, just so that there's no breakdown of communication, Judge, but we are asking for this to be considered time served, the 64 days. That would effectively be a recommendation of 128 days for 2-to-1.
Ms. Mitchell?
Your Honor, based on what PD Helen has stated, it's clear that he is in violation of the no further contact on the previous case.
Okay, well,
I'm
the
still
May 2019 battery family violence specifically, was there a no further contact on that bond?
I am looking at the bond document and I'm having an issue seeing the conditions of that bond. It's not the document that I'm used to.
Okay, what about on any of the, I know I put a condition on it, but that was the most recent.
Right. Let me see this other case. Let me check the November 21st one. Okay, I do not see the bond order on that case. And I'm going to check the one more. So on the criminal trespass family violence, let me get the exact one. So position 26, there was a clear no further contact with the victim.
Okay, and that was, what was the offense date of that?
May 19th, 2019.
Okay, so Ms. Helen, he was told back in 2019 not to have any further contact with Ms. Bazan. And had he not had contact with her, none of these other incidences would have occurred. As such, he was in violation of the court's order at that point in time. I am more inclined to go with what the state has recommended regarding each of these cases. So
I need a moment just to call Mr. Serrato, make sure he understands what that means. Can I get a moment just to call him?
you have the number?
I do. Courtroom 2, can you text me or chat me the number?
It's 404-612-2392.
Henry?
Oh, Judge.
No, hold on.
Courtroom 2, are we ready?
Yes, whenever you're ready, Judge. This is
Okay, I'm ready. Who is this?
position 13, Mr. Hamblin.
Okay, this is an arraignment, Mr. Finley.
That's correct, Judge Morrow.
Good morning, Mr. Hamberlin. I'm Judge Eric Morrow. This is a state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you. Mr. Hamblin, you've been charged in case 22 CR 002018J with one misdemeanor offense. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine.
Yeah.
Do you waive formal reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead, Mr. Hamblin? Guilty or not guilty?
Not guilty.
Blame not guilty.
We will accord your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date, okay?
Yes, sir.
All right, have a good day. Thank you, sir.
Yes, sir. Can I ask a question for you, sir?
Mr.
If I please, please.
Mr. Hamberlin, if it's about the facts of your case, I would recommend not say, sir.
Yes, sir. Well, would I be, can I bond out today?
Mr. Hamberlin, if you could, I spoke with your mom a little bit ago. If you could just hang by and we can talk on the phone.
Thank you. I'll sit down. Thank you.
No problem. And I addressed his case last week, I believe, and there was an amended bond order filed in this matter. Mr. Finley, are you aware of that?
I did just see that, Judge. That was the 5,000.
Yes, with the transport order.
Yes, sir.
Okay, so he should be transported by the end of the week.
Yes, sir. Okay, yeah, I did see
Okay.
that a little bit ago.
Okay.
Thank you, Judge.
All right. Thank you.
We can go over to yesterday, plain logo and
Okay, and thank you, Mr. Hamblin.
Thank you.
thank you. I don't know.
Give me 1 second, Judge. I have to pull the next person out from the tank.
Okay, that's fine. Let's see, let's see who we have on for the DV bench warrant calendar. I saw Mr. McCoy on earlier.
Everybody's here on the DV counter, Judge.
Okay. Okay, thank you. Mr. Finley, Mr. Campbell, are you handling the DV bench warrant calendar today, Mr. Finley?
I'm not, Judge.
And that's going to be Ms. Helen?
I believe so. How many people did we have on there? I never saw the calendar.
We have 3 on the calendar today. And who do we have in courtroom 2?
This is position 34, Youngblood.
Okay, and this, I believe this is Ms. Helen's client, so we're gonna have to wait till she returns. Okay, Ms. Helen, what are we doing?
So Judge, we are going to ask to be heard on bond today, enter a plea of not guilty.
Okay. So can we get, since we have him there, Ms. Helen, let's go on to Mr. Youngblood.
Yes, Your Honor.
He's gonna be a negotiated plea, is that right?
That is correct, Judge.
Good morning, Mr. Youngblood. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I swear, Your Honor.
Okay, thank you. You can put your hand down. Ms. Mitchell,
Yes, Your Honor, the state's recommendation is 12 months to serve, 30 days confinement, credit for time served 15 days, ballots probated, no further contact with Peter Trong, spelled Truong, a stay away from Sweet Hut Bakery on 935 Peachtree Street, Northeast Atlanta, Georgia, 8-week anger management course, 40 hours community service, and no alcohol, drugs, and weapons. Nothing further, Your Honor.
Ms. Helen?
Yes, Judge, that is our understanding of the state's recommendation. We do agree and we stipulate to the factual basis, venue, and ID.
Okay. Mr. Youngblood, it's my understanding that you wish to plead guilty to battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anybody forced you to plead guilty?
No, sir.
Okay, I'll accept your guilty plea, Mr. Youngblood, as negotiated. I am going to waive the probation fees while you're on probation to help you get and stay on your feet. And then once you complete the terms of the probation, it'll go to non-reporting status, okay? All right, good luck to you, Mr. Youngblood.
So I'll be released tonight?
If you get 2 for 1 from the jail, you'll be released when they process you out, okay, sir?
What you mean when they process?
The jail can let you tell you how they have to process you out and how long it'll take, sir.
Listen, I want to go back to Philadelphia. I do not like Atlanta. Can I get my probation switched to Philly, back home with my family? I don't like it here.
Okay, you can speak with the probation department regarding that, or you can speak with Ms. Helen regarding that, but that's something that we routinely do, so that should not be a problem.
All right, I appreciate that.
Okay, good luck in Philadelphia.
Mm-hmm.
All right, so
We're completed here in courtroom 2, Judge.
we still have Mr. Serrato to finish up with.
Oh, okay, come back.
All right, can someone tell me what the bonds are for each position, please?
Yes, Your Honor. So on position 20, where's the first one? Yep, position 26, the bond is a $4,000 surety as to count 1, and there is none on the second. Position 27 is going to be a $500 surety bond. Position 28 is a $500 surety bond. And position 30. So for the harassing communications on that case is a signature bond. And then for the obstruction is also a signature bond. So he has a signature bond on that case. For
How much is the signature, the signature bonds?
1,000, 500 as each count.
And what about for position 29?
Position 29, that those are a signature bond, Your Honor.
How much?
25, it's 500. Hold on. Just 500, $500 signature bond as to the expired or no license and the brake light turn signal violation.
So is it 500 each or 500 total?
500 total, 250 on those 2 counts.
Okay, and what about the obstruction or about the given false name?
Oh, my apologies. That's also a $250 signature bond. Am I missing one? I feel like I'm missing one.
Expired or no license on person is 1, brake lights or turn signal is 2, and giving false name is 3.
Yes, so 250 as to each, so that'll be 750.
750, okay. So he's got signature bonds on 29 and 30. He has $500 good bonds on 28 and 27 and 28. He has a $4,000 good bond on the battery family violence, and he does not have a bond on the cruelty to children.
Correct.
Okay. So That's the only one that I'm going to change, Ms. Helen. And it's going to be a $3,000 good bond for the battery family violence and a $1,000 good bond for the cruelty to children, making a total of a $4,000 good bond with all the stipulations that were on the first bond.
Understood. Mr. Sharado, did you hear that split of your bond? Did you hear that breakdown?
Yes.
Okay, so you understand you have a split bond. A portion of it's signature, a portion of it is surety. You'll have to bond out through a bonding company.
Yes.
Thank you, Judge.
Okay, so the only one I think that I need is position number 26, Ms. Helen.
Say it again for me, Judge.
The only one that I think that I will need for you to draw up for the court would be position 26.
Correct, Judge.
Okay, all right, just wanted to make sure. Okay, thank you, courtroom 2. We appreciate it.
All right, thank you, Judge.
For which one? Okay, I'm sorry. Well, we'll have to get them next time. Okay. All right, Ms. Helen, are you representing everyone on the bench warrant?
I'm not. I believe Miss Maya Campbell has her own representation, but positions 1 and 3, I am.
1 and 3. Okay, Mr. McCoy. Mr. McCoy is in court with me.
I believe it's Mr. Campbell's in court with you. I think Mr. McCoy's on
Mr. Campbell. Okay, good. Good morning, Mr. Campbell. All right, do you need to speak with him, Ms. Helen?
No, Judge. We can move right into the hearing if.
Okay, that's fine. And what about Mr. McCoy?
No, Judge, we can move right. He's present and
Okay.
has a screen on.
So Mr. McCoy has been here before. Actually, he's been here 2 times before. The last time he was here, it was my understanding that he was going to have to get me a new address for him to move to. Did he do that?
And we do have a new address, Judge, a complete move, okay? From the previous 961 Lean or Lena Street, Southwest Unit B, Atlanta, Georgia, 30314. That is a completely changed address. He now resides with his mother, Ann Johnson, okay, at 2950 Springfield Court, College Park, Georgia, 30349. I can also send her information in the chat just so we can make sure we have it updated. I want this information reflected because when I spoke to Mr. McCoy, he understood the seriousness of what was happening at the last hearing and made that quick and effective move to this address. And I just want to make sure that the court has it notated and updated that this is his current residing address and that he understands there is no contact with Miss Wilder, none, no third party, social media, nothing. She tries to contact him, he leaves.
Okay, and that was the understanding from our last hearing, Ms. Helen, last week. What would you like the court to do?
Judge, I'd ask that this bench warrant be set aside. I again would like that address reflected. When I spoke to Mr. McCoy, he understands the conditions, what's being asked, and that if this bench warrant is being set aside, this case is still open. He must appear for all court dates, and that all of the notice for this particular case will go to 2950 Springfield Court. There will be no more FTAs.
Okay, and Ms. Tortorello, I don't know if you were here last week, but he has complied with what the court asked him to do last week. Therefore, I will comply with.
Your Honor, before you make your ruling, Your Honor, we observed when the defendant turned on his camera. We know how the victim looks like. She was the one that turned on the camera for him and then handed over the phone over to the defendant. Therefore, right now they're actually having contact, Your Honor. To add, last week we were able to have contact with the victim, and now after he's been given a week's to get a new address, now we actually just today we tried to call the victim. Her phone's completely cut off. This goes to intimidation of witnesses, Your Honor. And we do ask, just based on that, Your Honor, to not set aside his bench warrant. He's not complying with his bond order. He also has made 2 violations, not only before Your Honor, but before a Chief Judge Edline in state court, where he did not appear to a court date on January 19, 2022. Judge Edline has actually scheduled him for a bond forfeiture on her bond forfeiture calendar, which is scheduled for June 10th, 2022. This defendant has more than 40 cycles on his record, so this is not his first rodeo. He knows how the criminal justice system works. He knows what's expected of him. And we ask, just based on this, Your Honor, that you do not set aside that bench warrant. The victim is right there with him, Your Honor.
Do you know that to be true, Ms. Helen?
I didn't see Miss Wilder. We can play back the recording because it is recorded and see if that's Miss Wilder.
Unmute, please, Mr. McCoy. Mr. McCoy, can you unmute yourself?
I'm sorry, Judge. That's my mother here with me, Young.
Let me see her. May I see your mom?
Come here, Mom.
Where the phone at?
It's right here, Mom.
Hi, sir. How you doing?
I'm fine. What's your name, ma'am?
Ann Johnson. Get up, boy. Let me sit down.
Hold on, Mama.
Ann Johnson, how you doing?
I'm doing fine, Ms. Johnson. Can you raise your right hand for me, please?
Yes, sir.
Swear and affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Ms. Johnson, is Ms. Wilder there with you?
No, she's not.
Has she been there at all today?
Not today, but when you had a talk a little earlier, he had said that nobody ever told them that they couldn't be together, and immediately I had told him anyway to come to my house.
Okay, and he's living there with you now?
Yeah, he got to stay here with me for a while anyway because he's going through some medical issue with VA.
Okay, all right. Thank you, Mr.
Your Honor.
Yes, Mr. Walker.
I'm sorry. Might I have the opportunity to question the witness? I'm the one who actually observed the camera being turned on the Zoom.
Go ahead, Mr. Walker.
I'm sorry, ma'am. What's your name again?
Ann Johnson.
Ms. Johnson. So have you been assisting your son with this case today as far as operating the phone?
Have I done? I hope he learned. He learned.
I'm just saying, have you helped assist your son in operating the phone that you're on right now?
Did I do what? Assist him?
Did you turn the phone on for your son and hand him the phone earlier during this calendar?
No, did I do it?
Yes, Your Honor. I mean, yes, Ms. Johnson.
No, I didn't assist him with handling the phone. What's going on?
Okay, that's all. That's the only question I have, Your Honor.
Did anybody assist him to your knowledge, Ms. Johnson?
I don't know, because when he first got on the phone, I was on the side.
Well, you should know if there's anybody else in your house, ma'am. Is anybody else in your house?
What, right now?
At any time since we've been on the phone, or since he's been on the phone?
No, ain't nobody else in my house right now.
Okay, what about 5-10 minutes ago? Has anybody been in your house besides your son all day?
Other than my husband. And he's not here, he gone to work.
Okay. Anything further, Mr. Walker?
I have no further questions for his mother. I will just say, Your Honor, as you're aware, this is recorded on YouTube. When the camera came on, it was a female who turned the camera on and handed the phone to the defendant. I have went back and watched the body camera and laid eyes on the victim, and that person, unless she has an identical twin, appeared to be the same exact person. As we just heard the testimony from the defendant's mother, she has not helped him operate his phone today.
No, I haven't.
Just by the mirror, you say you have now?
No, I never did say I have to operate the phone.
Okay, so to my point, just by the mere fact that prior to last week, we had good contact with the victim, and he was given a 1-week reset to get a new address, and all of a sudden now the victim's phone is disconnected. As I previously stated, it appeared that the victim was the one who turned on the phone, not his mother. I have reviewed the body camera. It does appear to be the same person. Based on that information, it appears that the defendant is still in direct violation of his bond, and we asked.
No, ain't nobody here but me and Cyrus
I
now.
understand, and I asked if this bench warrant is not set aside. To be frank, the defendant is playing games with the court. This has all been recorded and is viewable on YouTube. So as the mother has testified earlier, she was not the one who came to the phone earlier. She's not the one who turned the camera on. She's not the one who handed the phone to the defendant. And upon my review of the body camera, it appeared to be the victim. So based on that information, the state's asking that this bench warrant not be set aside because it appears that the defendant is still in direct violation of his bond as we speak.
When is his next hearing date, Ms. Tortorella or Mr. Walker?
What I see scheduled is a bond forfeiture. He's on a bond forfeiture calendar for Judge Edline on June 10th this year, Your Honor.
All right, so I'm going to let y'all deal with it then, okay? So as far as this goes, I'm going to set it aside. He's got another hearing. You can present what you need to present, Mr. Walker, at that time if you want to go back and get that. And you can even get this if you'd like to present at that time to make your case, okay?
Okay, thank you, Your Honor.
Looks like we have a date certain. So Ms. Helen,
the one that that did the one.
make sure that you know that he has that hearing date, and and that he shows up for it, and you all can address it all at that time. Okay, as far as this goes.
Oh, wait, Mr. McCoy,
Mr.
please.
McCoy,
Mr. McCoy, please.
Am I allowed to say something?
Mr. McCoy, no, you're not allowed. Just don't say anything right now. You have a lawyer. I'm gonna set aside this warrant, but you have another hearing date coming up in the very near future. Okay.
Thank you, sir.
They'll address it all, and Mr. Walker will get to the bottom of it. So, all right.
What date is that going to be, John?
You should have gotten, well,
I'm not.
Ms. Helen, you have his information?
I do, and I will follow up with Mr. McCoy as soon as we can get off the Zoom call, Mr. McCoy. Thank you.
Thank you, ma'am.
She'll be in touch with you.
Thank you, ma'am.
Okay, so let's go on to Mr. Campbell. Come up to the microphone, please.
I will just say I don't know, man.
Mr. McCoy, you can leave the meeting now, Mr. McCoy.
How do I do
can
it?
Still hear you.
State Court, can you help Mr. McCoy?
Over here, sir. Good morning, Mr. Campbell. How are you? I'm Judge Eric Morrow. This is the DV bench warrant reset date. What do we have on Mr. Campbell?
From the
Ms.
state judge,
Mitchell,
or you?
Let's start with the state. Is this your case, Ms. Mitchell?
Yeah. Yes, Your Honor. What do you mean? What do you mean by what do we have? I didn't know.
Okay, apparently he didn't show up for a court date. How many court
Right.
dates has he not shown up for? What court date did he miss?
Okay. The defendant FTA'd on his plea in arraignment on May 4th of 2021. He submitted an address change on January 5th of 2022, but then he failed to appear on his plea in arraignment on February 22nd of 2022. On February 21st of this year, the defendant actually called in repeatedly over the past month at that date, asking us to drop the charges on him. And the next day was his hearing. So to me, that shows that he knew that he had a hearing and he still failed to appear the following day. And then on March 1st of this year, the defendant called in and stated he didn't receive notice of his last hearing on February 22nd, and that he'd been calling consistently for the past few months regarding the case. He also stated that he had been calling the victim, and the victim blocked him from calling her, and that he's been trying to speak with her, but she says she doesn't want contact with him. So he is in violation of his no contact with said victim, both her and her daughter. The defendant also states that he currently now lives out of state based on our notes. So based on that, Your Honor, the state is asking that the court not set aside the bench warrant in this case.
Ms. Helen?
Yes, Your Honor. When I spoke to Mr. Campbell last week, he's 51 years old. He was not able to utilize the Zoom link or the technological utilities to log in on Zoom. That's why I asked him to come in person. When he came in person, I spoke to him about these charges. I spoke to him about the case. He knows to have no contact with Sophia Robinson. So I'm a little confused about the dialogue that he may have had with others saying he was trying to contact them. We had a very clear contact or conversation about the accusations that list Miss Sophia Robinson and that there's no contact, that list his daughter and that there is no contact. And when he spoke to me earlier this morning, he told me he had no contact with those individuals. So when I spoke to him, we have an updated address of 3030 Continental Colony Parkway. I believe maybe there was an issue. He left off the apartment. The apartment is 903 Atlanta, Georgia, 30331. When I spoke to him, he was not under the impression that if your apartment number is not on there, that you won't get notice. So I had to inform him that that is exactly what is occurring, because he said his address hasn't changed, that it's been exactly that one, apartment 903. When I spoke to him about the FTAs from May 4th, 2021, he had no notice. Again, this update of address was just recently entered, Judge, January 5th, 2022. And again, the issue of the February 22nd, 2022, if that was a Zoom link, I believe that there was an issue of technological issues. That's why I asked him to show up in person today. So we should not have any more FTAs, any more issues of contacting him, getting in contact with him. And so again, when I spoke to him, he knows there is no current contact with the people who are listed. He has been laid off, but he was currently working prior to that layoff with Coca-Cola as a utility worker for years. So Judge, yes, we are asking for this bench warrant to be set aside. With all of my clients, I am clearly telling them and stating there is no contact with these alleged accusers. You're not living with them. You're not talking to them, no phone contact. He understood that. So again, I'm just confused about the conversation. He said he's trying to contact these individuals. That's not the case because we've already discussed it. So Judge, yes, we are asking for this bench warrant to be set aside.
Ms. Mitchell, does he have another hearing date scheduled?
Not from what I was able to see, Your Honor, not at this time.
Okay, well, he's shown up here in court today. I think that that says something about his willingness. I'm going to give you one more opportunity, Mr. Campbell, okay? So you've got your address. If you miss one more hearing date for whatever reason, then they're going to put a bench warrant out for you. It's not going to be set aside the next time, okay? All right, so even if you need to keep checking month by month to make sure that you don't have anything coming up, just to make sure on your end. But I will set aside this bench warrant, but I don't expect it to happen again, okay? All right, and it's mostly because you're here today standing before, okay? All right, good luck to you, sir. All right.
Thank you, Judge.
All right, position number 2, Maya Campbell Monclova.
Good morning, Your Honor. Attorney Catherine Edmonds here on behalf of Ms. Campbell Monclova.
Good morning, Ms. Edmonds. Ms. Mitchell,
yes.
I take it that there was allegations that she missed a hearing date?
Yes, Your Honor. So the defendant was let out on a signature bond and she FTA'd on March 7th of this year. We've been given no reason as to why she missed it. It doesn't appear she's been in contact with our office. As Your Honor knows, it's the defendant's responsibility to update the court with their current address and to be responsible for these hearing dates. again, because she was let out on a signature bond, she was given a chance. And she understood her responsibility to show up to the hearing and failed to do so. So we're going to request that this bench warrant not be set aside, as she knew that if she didn't show up, a bench warrant would be taken out for her arrest. Nothing further, Your Honor.
Ms. Edmonds?
Thank you, Your Honor. And if I could just shed a little bit of light on this situation. It's my understanding, and Ms. Campbell Monclova hired our firm yesterday, but it's my understanding that she was told by a pretrial officer that her court date would be April 4th and wasn't aware that it was March 7th, which is why she missed it. She has since updated her address with the court and has since hired counsel. So we are here to make sure that she doesn't miss another court date. It was just an honest mistake, and she does intend to come, to be present for every subsequent court date, and we will ensure that she does not miss another one.
Have you already filed your notice of appearance, Ms. Edmonds?
I believe we have, Your Honor.
Okay. All right. So I'll give you one additional opportunity, Ms. Campbell Monclova. I'll set aside this bench warrant. This time you have counsel, so she should be getting the hearing dates going forward. Okay. So you get one chance. You if it happens again, then the bench warrant won't be set aside. Understand? You're on mute, but I take it that that's a yes.
Yes, I do.
Okay, very good.
Thank you.
Anything further, Ms. Edmonds?
Your Honor, just that we would request discovery. I believe we have filed motions requesting that. I don't know if we would get that at this time or after that next court date.
Ms. Mitchell, if you can work with Ms. Edmonds to get her to discovery, please. Whoever the solicitor is that's going to be taking on the case, I take it.
Sure.
Okay.
Thank you, Your Honor.
Ms. Edmonds, can you go ahead and chat me your email address?
Absolutely, I will do that right now.
Nothing further, Your Honor.
All right, thank you. So let's see, we've completed the two calendars today, and I have Ms. Middlebrooks in court with me. If you all will, if you have not already gotten her your paperwork, please go ahead and do so. And as soon as she's ready, we'll go over the calendar.
Your Honor, is there any way we can go on a breakout with a public defender, Finling, to discuss the DuBose case?
Is that a case that's on the calendar?
Yes, Your Honor.
Yes, Your Honor.
What position is that?
I believe she's position number 8.
Okay. And what, just the two of you want to go into a breakout?
If that's fine. I mean, I thought you'd like to.
I mean, so I have for Ms. DuBose, there was a mental health reset. Is there something that's changed on that?
I would like to offer a signature bond with conditions. I'm concerned about her. I've read the facts of the matter of the case, and I am concerned. I believe we are consenting to no violent contact with the victim. I'm not sure who her guardian is. I'm not sure if the defendant is competent. So that's why I wanted to break out and maybe have a discussion.
Okay, all right. So let's do this. We've got everyone on the line here. Why don't we go over the calendar first, then I can release everyone that doesn't have to do with Ms. DuBose's case, and then we can discuss her case. Can we do it that way?
Sounds good. Thank you, Judge.
Okay. We're ready to go over the calendar. Okay. Position number 1 has been released. Wait, can everyone hear Ms. Middlebrooks? Hello? Is anybody listening?
She needs to speak up.
Ms. Harrison?
Little bit.
Okay, so you all tell, she's gonna start, we had problems with this yesterday, that's why I'm asking. So you all tell me if you cannot hear her. Go ahead.
No, can't hear her.
Can't hear her.
Okay, so let me do it. Do you mind, Ms. Melba? So you make sure that I'm right. Okay. Position number 1 was released. Position number 2, there's a transfer. Position number 3 was a plea. Position number 4 was a plea. Position number 5 was arraigned. Position number 6 was arraigned. Position number 7, $3,000 signature bond through the jail. Position number 8, we're going to discuss. Position number 9 was a plea. Position number 10 was a plea. Position number 11 was a plea. Position number 12 was a plea. Position number 13 was arraigned. Position number 14 was a plea. Position number 15 was arraigned. Position number 16 was transferred. Position number 17 was a plea. Position number 18, 19, 20, 21, all were arraigned. Position number 22 was a plea. Position number 23, 24, 25, 26, 27, 28, 29, and 30 was a bond.
Well, Judge 29, yes, Judge, sorry, I apologize.
Position 31 was arraigned. Position 32 was a plea. Position 33 was a plea. Position 34 was a plea.
Correct, Judge.
All right.
And I'll get those bond modifications to Ms. Middlebrooks.
Say it again, Ms. Middlebrooks. I have 14 as a non-negotiated plea. Is that? Oh, you're right, you're right. So position number 14, $2,000 SOB through the jail. Was going to be a plea. Okay, if you all can make that modification on 14. Any other questions? Okay, so why don't we do this? Instead of going into a breakout room, why don't we, since the same effect is, if we can go off of YouTube, Miss